We are waiting for our principal, sir.
Sir, Panchal sir may be calling Patil sir.
Yeah, I know. I think.
Panchal sir,
Yeah.
I already contacted principal sir. Within 2 to 5
Yeah.
minutes, they will join. Okay.
Yes, sir. Yes, sir. Yeah. Thank you, sir. Yeah.
Okay.
Yeah.
Panchal sir.
Yes, sir.
Yeah, Patil sir is in the meeting.
Okay.
Okay. Patil sir,
So,
good afternoon.
Good afternoon.
Okay, sir. Around 126 count is there. Can we start?
Yeah, please.
Okay. Panchal sir, over to you, sir, please.
yes, sir. Shinde sir and Pratik.
Pratik.
Yes, sir. Yeah. Good to start, right?
Yes.
Okay. Yeah. Thanks, sir. So, first of all, very good afternoon and happy Republic Day to one and all. Thanks for joining this session. So, first of all, hi, this is Pratik Joshi. Talk organize. So, first, Mrs. Saili ma'am, I'd like to welcome our honorable principal, Dr. S.P. Patil, Ancha sir, who is the HOD of the mechanical department, and participate. So,
Pratik, your voice is breaking. Make sure that you are in good network. Pratik, unmute yourself.
Hello. Yes, sir.
Ah, ah.
So yeah, now I request to the Shinde sir about our today's chief guest.
Okay, good afternoon, one and all. This is my pleasure. Today we have one of the most eminent personality with us, Professor Saili Bidwai Madam. So I want to give the introduction of the madam. Madam has completed graduation in Bachelor of Engineering in Electronics Engineering. Madam also completed his Masters in Electronics Engineering. Currently, Madam PhD pursuing from VTU Belgaum. Madam also completed her diploma in Intellectual Property Law. Madam has 15 years of academic experience. Currently, Madam working in MIT College, Alandi. Madam has published 9 journals and 12 conference papers. Madam has conducted more than 16 programs for faculties and the students in various institutions and the organizations, including intellectual property right, that subject. Madam has also participated and attended more than 18 training programs, conferences, webinars, and the seminars. And one thing I want to mention all of you that Madam received one award, Distinguished Assistant Professor Award from Computer Society of India. Madam also filed a patent, industrial design patent of composter machine. Madam also achieved Best Participant Award of Training Program, which has titled Advances in Signal Processing using VLSI. Madam also Executive Director at Incubation Center, named as Center for Development of IoT Enabled Smart Public System. Madam also initiated and incubated four startup of the student over the year. This is the introduction of the madam. Now I hand over the chair to the Pratik. Thank you, Pratik.
Yeah, thank you so much, sir, for introducing our today's chief guest. Now I request to Dr. SP Patil, sir, who is the principal of KEC College, to guide us. So over to you, sir.
Thank you, Pratik. Today's speaker, Mrs. Saili Bidwai, Head of Mechanical Department, Professor Pancha, Dr. Utpat, Professor Jagdish Mudegaonkar, Professor Babar, Professor Shivpuje, Professor Joshi, all faculty members from mechanical and other departments, and dear students. It's good to know that Mrs. Bidwai is going to deliver a lecture on intellectual property rights. She was my colleague in the previous institute. Now she is working with MIT Alandi. And she has done diploma in IPR. And she has conducted many such programs to guide the faculty and students for filing IPRs. She is a good teacher. And beside this, she is working on a research area in VLSI. I'm sure that students, especially final year students of mechanical department who are studying this subject, intellectual property rights, and for these students, definitely today's lecture would be a great benefit. And of course, all my colleagues are attending this lecture. So in future also, we can have a 1 day or 2 days workshop on the same topic for the faculty so that we can work in this area and we should come out with some patents filing. So without wasting much of time, I wish all the success to this program. And the Department of Mechanical Engineering, I congratulate this department for organizing this webinar on IPR. So, and thanks for giving me an opportunity to speak with my students. Thank you.
Thank you so much, sir. So now I would request to Dr. Abed Patel, sir, to guide us, who is the head of the R&D affairs, Karma Yoga Engineering College. Over to you, Utpat, sir.
Good afternoon, everybody. Am I audible?
Yes, sir, you are.
Yes, sir.
So, respected dignitaries present over here, today's eminent speaker, Professor Mrs. Saili Bidwai, respected principal of Karma Yoga Engineering College, respected Patil sir, Vice Principal Mudegaonkar sir, all head of departments, and my respected student friends. So today is very important session on IPR. As an engineering student, getting the engineering degree is not only sufficient until and unless you will present yourself in the society in the form of research. So in old era, maybe 10-15 years back, there was the scenario that people were presenting the papers in the various conferences, journals. Now this becomes very common thing. And now in the forthcoming years, it is expected that not only teachers, but also students should file their patents. And it doesn't mean for filing the patent, you have to do some very big research. No, only if you have idea in your mind, you can file the patent. If you search, there are very simple patents filed, but the idea behind or logic behind is tremendous. So you will be very happy after end of this session when madam will explain you all these things. This is just introductory session. As mentioned by respected principal, some 1 day or 2 day sessions or workshop is to be conducted for faculty and students. So definitely our aim or our target of the Karma Yoga Engineering College will be in forthcoming years, not only faculty members, but also students will also file their patents based on their ideas. So I request Madam Bidwai to please give assurance that in future also, if some kind of sessions are expected, you please make yourself free, madam. And definitely today's session, we are very eager to listen to you. That's why thank you organizers for giving me chance to share my views. Over to organizers. Thank you.
Thank you, sir. So now I request to Mr. Pancha, sir, who is the HOD of Mechanical Engineering Department. Sir, please guide us. Over to you.
Yeah. May I audible, Pratik?
Yes. Yes, sir, you are.
So thank you very much. Respected dignitaries, our trustee, Rohan Paricharak sir, our principal, Dr. S.P. Patil sir, Vice Principal, Professor Mudegaonkar sir, Dean R&D, Dr. Abed Patel sir, all HODs, my colleagues, and my dear students. First of all, I welcome to all of you in today's webinar on intellectual property rights. So today we are gathered here by online mode for expert talk on IPR. Actually, this topic is nothing but the subject for the final year, as the principal sir mentioned in his talk. So we thought about that this is not only the useful for our mechanical students, but it is definitely useful to the other branch students also. So we make that the such an arrangement that, and the principal sir had given the permission to us to conduct the webinar for all the students. So I just elaborate to you here that after successful completion of this webinar, definitely students will get idea to how to use IPR in their curriculum or in their project itself. So once again, I welcome to our eminent personality, Mrs. Saili Badwai madam, and I wish all of you happy Republic Day. So thank you very much. Pratik, over to Pratik.
Yeah, thank you, sir. So without wasting much time, we all are eager to listen Saili ma'am. So I would request to the Saili ma'am. So ma'am, please take a charge of the mic. And yeah, over to you, ma'am.
Thank you so much. It was really a warm welcome. I'm privileged, in fact, to contribute in the development of nation on this Republic Day by sharing some of my knowledge to the budding engineers. I really owe much to Dr. S.P. Patel sir, because I was not only working with him, but I was even his student. He was my guide, and at the same time I got an opportunity to work under him in very early days of my career, and the opportunities which he gave, because of which we could explore much, and now we are at the level where we are now. So I thank everybody, team of Karma Yogi College, for giving me an opportunity to share a few of my thoughts related to intellectual properties. And let us see, over the period, I hope my inputs would be useful for the students as well as for the faculty members. So, is my voice clear and audible?
Yes, ma'am.
Okay. Let us start a discussion. Precisely, I'm calling it as a discussion because I'm not going to give a lecture. I would be expecting somewhere in between if there are any doubts. And if at all you have any questions, you are free to ask and interrupt me anytime. So, what exactly we are going to discuss today is why one should know about IPs. I was happy to see that there is one subject, though it is only an audit course, but at least it is one of the subjects in the curriculum given to mechanical engineering students. Yes, I was really happy to see that, because most of the institutes now, they are starting their efforts towards understanding and creating awareness related to intellectual property, because it is need of time. So first of all, before entering into any technical or techno-legal stuff, we will try to understand why one should know about it. Then slowly we'll understand the concept of intellectual property and the rights offered about it. Then we'll see types of IPs. There are actually multiple types, but prominently we make use of these three types of IPs a lot in our day-to-day life. So we'll see them in detail. And then I'll give you some takeaways. So this lecture would not be only one complete stuff, but it could be treated as a beginning of your journey to work and to generate IPs. So that way, what you can take with you some inputs that we'll discuss at the end. Now, trying to understand why one should know about IPs. So this is the total ranking of World Intellectual Property Indicators. So this particular information I referred from World Intellectual Property Indicators 2021. Even if you Google it, putting these words as it is, you will also get the similar document. So from that document, I could know that who is highest in filing patents. Marks means trademarks and designs. At left-hand side, first column, you can see the originating nation. Originating means the inventors are from which nation. So Chinese inventors are number one in filing patents, as well as in filing trademarks, as well as in designs. So three major, three major IPs all over the world are being conquered by Chinese inventors. So it has also ahead to United States. US, we consider the top in the world. But if we look in the perspective of intellectual properties, China is number one. See, in our day-to-day life, the gadgets, specifically the electronic gadgets which we use, we usually say, like, if it is Chinese, it will either run for an hour or it may last for longer. So we don't give guarantee to the gadgets which come from China. So this is how we look at it. But they have got such a strategy, such a mechanism, be using which the whole country is capable of producing from lowest to highest quality electronic goods. And depending upon the economy of other countries, they export their goods. So India, being not much richer in economy, they sell us cheaper product. So cheaper naturally will not have any guarantee of work, as well as they'll cheap even in the cost. But we must not forget that it is top in the world at the moment. And now, if you see where India is at almost last position. We can feel little bit of proud to be one of the top 10 countries. But still, there is a long way to go, because you can see here Germany, Japan, Korea. A small country like Korea is also far ahead of us. And this is the reason at least a literate Indian must know about IPs. And this is the reason why we are creating awareness. It is a later part, why the subject is there in your syllabus, what are the contents of that syllabus, that comes later. But basically, why one should know it? It is because if we want the number of India to go higher, then at least we should know the meanings of all IPs. Now let's see what exactly is an IP. We have been talking about it for quite a long. Intellectual property. Intellectual means something related to your brain, something related to your intellect. And property is like any other property. The way you have houses on somebody's name, the property in routine language, the word property as we use, exactly the same meaning applies to also the intellectual property, because it is one's property. Just the thing is, it has emerged out of the creation of mind. It is creation of mind, but still it remains the property. Okay, so the way we have vehicles, land, homes in our name as our property, the way I can buy a property, a normal property I'm talking about, the way we can sell a property, we can give on lease, we can give on rent, though it is a vehicle or home or land. We can sell, buy, put it on rent, or even we can mortgage it. So all these things can also be done with intellectual property. The only condition is you should have that intellectual property in your name. Means for making it on your name, you have to follow some legal procedure. It is not like that you are inventing something every day and you are keeping it as it is and you are saying that is your intellectual property. That can be your invention, but it becomes an intellectual property when you formally go for its legal registration. You get the protection over your intellectual property only after you filing it. So, concept of IP is only this, that it is creation of mind and it has got all the rights very much similar to any other hard property, any other tangible property you have. Now, you might have heard there is act, there is law related to any other property. Exactly the same way, intellectual properties are also governed and managed by its laws. As there are different types of intellectual properties, they have separate acts, laws, and rules associated with it. For example, patent, copyright, trademark are some major types of intellectual property. Accordingly, there is a Patents Act, there is a Copyright Law, there is a Design Act, there is a Trademarks Act as well. And there is a set of rules for each of them for their operation. Now, you might think when we are saying creation of mind, so now by sitting over here, by listening to my lecture, you might think of an innovative idea. Innovative idea might not always be a big invention, a breakthrough invention. It is not at all mandatory. You can also imagine a poem. If you are not really focused in this lecture, you might, start composing your own poems. The moment you write that poem on a paper, that becomes your intellectual property, because that is a novel creation of your own mind. So that creation, once it comes to a tangible thing, that becomes your intellectual property. Now, when the property is created, that is your own. But if you want others, if you want to prohibit from stealing it, from selling it, in that case, you need to file it in a legal procedure. So as I mentioned, while listening to this lecture, if you compose a poem, if you write that poem on a paper, suppose till the end of this lecture, if you write 10 poems, so that will become a small booklet of poems. And that written documents, 10 pages, can be published as a book. Now, before publishing, if you want to protect your right, if you want others not to take away without your permission, then you have to file it as an intellectual property. And usually such literary work is termed under copyright. So it is creation of your mind, it is an intellectual property, but because it is a literary work, it goes under copyright. So anyway, we are going to discuss in details which invention, which creation of your mind can go in what category. But just for an example, I told you, creation of mind is intellectual property. What can be considered as an IP? So this intellectual property, now onwards, I would be saying as IP. It is not internet protocol. It is intellectual property, at least till the end of this session. What can be considered as an IP? Any kind of invention, any type of literary or artistic work. Literary means play, katha, kadambarya astat, so those stuff. It can be a research paper, it can be a book, it can be a novel, it can be a poem, a book of poems, or an artistic work like a painting, a pencil sketch, a drawing of a building. Okay. Then there are different types of symbols. So you might have seen hundreds of symbols. Now also, if you see around you, you will find at least 10 different symbols. Such symbols are also kind of IPs. There are some names and images which are associated with some specific brands. They are also intellectual properties. So all this stuff which directly or indirectly is associated with commercial world and is creation of mind can be considered as an intellectual property. So your brain can think of an invention, your brain can generate hundreds of ideas of inventions. Our mind can also think of different designs. It may be a design of a machine, design of a building, or a simple artistic design. There can be symbols, there can be names and images. So all this stuff which is coming out of your mind and which is somehow associated with commercialization, so that becomes an IP. Then what are the rights? So as I mentioned, there are different types of IPs, but if you want to protect them, then you have to follow a legal procedure, go and register a particular IP, take its legal rights, and then only you can prohibit others from stealing or using it without your permission. Let's see what are the types of IPs. Broadly, the intellectual properties are categorized into two parts. One is industrial property and another is copyright. Industrial property is in one way or the other linked with industries. It can be production of industries, it can be symbolizing the industry, it can be a branding of it, but it is more precisely somehow linked with industries. So all such IPs are called as industrial property. And copyright is something which somehow comes on paper, not precisely paper, writing material. So this is a very broad classification of intellectual properties. Let's see what comes under industrial property. Patents for inventions. So if there is an invention, we can file a patent and that patent is considered to be an industrial property. Why? Because we can do its mass production. So somehow it is related to industrial property. Then trademarks. Trademark means, for example, symbol of Nike. You must have used shoes, bags, caps of Nike. At least you might have seen it. Huh. May I know what is the symbol of Nike brand? I want any of the students to respond.
Right.
A tick mark. Correct. Correct. So it is simply a symbol, but it is associated with some industry. It is a brand symbol of an industry. So trademarks are also considered as industrial property. Then industrial designs. So when I say industrial design, it means the design of a manufactured good. For example, when I say Bisleri bottle, you imagine a specific shape of the bottle with a tag with a label, with a specific color, and the name of Bisleri written in a specific font. This is one. When I say Coca-Cola bottle, now you can imagine a different shape of bottle, a different label, which is wound around it, isn't it? Now, though both are bottles, though both are containing some kind of liquid, but they both have different industrial designs. You might think, why Coca-Cola might not have thought of having the same shape of bottle like Bisleri has? It would be easy for them to just copy the design, use the same mold for manufacturing the bottles even for Coca-Cola. But they did not do it, because the moment Bisleri has filed a patent, a design patent, or more precisely, industrial design, because of which nobody else can copy the design even of a bottle. Forget about the content, what that bottle contains. We are not talking about that. We are talking about specifically the ornamental shape, the exterior shape of a simple Bisleri bottle. So, such designs of any manufactured good. Now, I gave you a very simple example of bottles. Now, you just imagine, just think about the shapes of mobile phones, screens of mobile phones. You have got hundreds of variations in the shape. Earlier, we used to have mobile phones with buttons. Now we don't find buttons on the mobile. Then after those buttoned mobile phones, there was a fashion of flap, a mobile with flap. Now that is also gone. Now what we have is touch screen. Now, though it is touch screen, you can also imagine how many companies are manufacturing, and you don't find any mobile phone of one company looking similar to other mobile from other company. You will not find, because they have got intellectual properties. If at all by mistake somebody tries to do so, there are big, hefty lawsuits against it. So this is industrial design. Then comes geographical indication. Why we are calling it as an industrial property is because geographical indication is a collective intellectual property which a group of people has to apply. For example, Nagpur orange is a geographical indication. It is a type of intellectual property awarded to a group of people living in the locality nearby Nagpur who produce a specific brand of oranges. It's not like if somebody comes from somewhere and he plants some orange trees somewhere nearby Pandharpur and they are calling it as Nagpur orange. No, it is illegal, because the flavor, the aroma, the taste which Nagpur oranges have, it comes because their locality. It comes because of their geographical location, and hence it becomes a geographical indication. And we cannot call anything, I mean any other oranges which are farmed somewhere other than Nagpur as Nagpur orange. It is illegal because they have protected their right. Now you might think it is a plant breed, then how one can call it as industrial, agricultural industry, and its product is nothing but Nagpur orange. So considering agricultural industry, the geographical indicators are also considered as industrial property. Now, all the examples which I gave till now are some way or other way are connected to industries. Though it is an invention, though it is a trademark, industrial design or geographical indication. So somehow they are linked with industrial property industries, so we call them as industrial property. Now let's see how copyrights are different, because both are intellectual properties, both are creations of minds. Then why do we have to categorize them like industrial and copyright? So let us see what comes under copyright, and then we'll try to understand the difference. Novels, poems, plays are all written material. Obviously, they are creations of human minds. Film means the stories, scripts. Music means the musical notation which one can write on paper, which one can print on paper, or which one can write on CDs. The word writing is same. So ultimately, the thing what I mentioned earlier, something which can be written. Now, whether it is writing on a paper or writing on a CD or writing on a DVD or writing on a hard disk, but we are ultimately writing it. Anything that we can write becomes copyright. Very simple to remember. We can write novels, we can write film scripts, we can also write music, though on a paper as a musical scripting language or on a CD or any other disk. Artistic works like drawings, paintings, photographs also, and even the sculptures, korev kam. So that sculpture also is considered as a copywriting material. Then the architectural designs, as I mentioned, designs of buildings. Burj Khalifa. It has got a very unique and a particular type of architectural design which has been copyrighted. Nobody else in the world now can have the same structure, architectural design of any other building because it is already protected legally. So such all things which can be written, which can be printed are coming under copyright. Now, rights related to a copyright include those of performing artists, now, with whom the rights will lie. If there is a live performance of any artist, the recordings of that live performance, the rights of which will lie with the performing artist. If there is a phonogram or recordings, so for example, you might have heard that there are raids on some CD or DVD shops. Why? Because the original CDs, the original DVDs are copyrighted material. And if somebody else wants to watch a movie using a DVD, it was, of course, earlier days, it used to be a lot. Now we watch movies on either Netflix or Amazon Prime, or we have many other mediums. Even after a while, it comes on YouTube, free of cost. So that is a different story. They also have a different way of copywriting. Okay, but such rights of original CDs and DVDs lie with the producer. If you purchase an original CD, its money goes directly to the producer of that movie because the rights lie with them. If somebody is broadcasting a match, live match, so broadcasting, if it is there, then their radio and television programs own the rights of it. Though somebody else is playing, though it let that be a match between India and Pakistan, but the one person who is broadcasting it will own the rights of that recordings because he is live streaming. So ultimately he has to take images, take live videos from the ground, and he has to send it to satellite, and then it reaches to everybody of us. So the person who is taking these efforts will carry its rights. Okay, now summarizing, there are basically broad categorization of IPs in terms of industrial property or copyrights. But you can see there is one more thing I wrote in the slide, that is trade secret. So though trade secret being an IP, we never publish it because it is a secret. Secret has to be kept secret, isn't it? Trade secret is something which never goes or which never enters the legal registration process. You have to precisely protect it by keeping it secret. You might think what type of IP it is, who is going to own this? Okay, I'll give you one example. Have you ever heard that there is a copyright of recipe of say Domino's pizza? Or you can take any beverage, any cold drink you take. Have you ever heard, or have you ever seen on internet their recipes are published? No, because they are their trade secrets. If Domino's pizza loses its taste, who will go and purchase it? Because they are expensive, though they are brands, but if they publish its recipe to everybody else, no one will go and buy it. Am I right? So trade secret, it is an informal kind of type of intellectual property. We never count it as IP, but yes, it contributes in trade, it contributes in business a lot. You can see food industry is going like anything. If we don't get any other stuff, that is okay. If you don't get to listen to a lecture, you won't mind, but you will definitely mind if you don't get anything for eating. So this food industry specifically depends completely upon trade secrets. So though it is an IP, we don't have any legal procedure as such. So this is a very broad overview of types of IPs. We'll see what type of legal right. It is a kind of a little bit revision of all these IPs. Legal right of patent can be owned if you have an invention. Now, this invention can be in the form of a product or a process. You may find out a process of creation of some medicine. In that case, that process, being inventive, can be protected under patents. How one has to go for it? So we actually have to file an application. That application goes from an examination and a series of reviews. Then it will be granted. So of course, there are two possibilities. It can also get rejected, but if it gets granted, then it will get a protection period of 20 years. So from the day of filing, we get protection of 20 years. What stuff we can copyright? Any literary or artistic work can be copyrighted. It exists automatically. As I mentioned, if you write a poem on a paper of your own, of course, your own poem, if you write it on a paper, that becomes your copyright. But if you want that nobody else should take it or publish it on their name, then you have to register. So formally, one has to register the literary or artistic work through online or offline mode. And once granted, you get the protection of lifetime plus 60 years. This, I'm telling you, vague. As if it is a literary work, it has got little more, detailing. If it is an artistic work, it has got little different detailing. But on an average, whoever owns a copyright can get its benefit up to lifetime, and the person who will get its right after the lifetime of the author after 60 years. So the total time period would be lifetime of the author plus 60 years. So this 60 years would be enjoyed by the children or somebody else who will own the copyright after the lifetime of the author. There is trademark. So what can be considered as a trademark? Any distinctive identification for a product or a service. Now, what makes it different? Distinctive identification means logo you can consider or a symbol you can consider. Very particularly they are writing product or a service. Now when I say bank, banking services, when we say bank, you immediately recall in your mind one symbol, a circle and a keyhole in it. Isn't it true? It is very easy to recall. But when we say State Bank of India, let us suppose, the moment we say, you will imagine a blue colored circle with white keyhole in it. Banking is under a trade. I mean, it contributes in trade. But does it produce anything? No, it is simply a service. But still it has got a logo. Okay. The same way you may have different logos for different products and also services. So the meaning of it is services will also carry a trademark. The way products will carry. Nike, as we have seen, Nike has that tick mark as their trademark. Okay. So how this trademark can be utilized, I mean, protected? It has also got, it's a separate registration process, but the priority will be decided on use. For example, the same keyhole, before banking services have started, if somebody else was using the same symbol for their own business, for another purpose, then that particular business would own that trademark. They can claim their priority. Okay. But ultimately, if they want to prohibit others from using it, they have to go for a legal registration process. And once granted, the trademarks get 10 years of protection. And this is the only IP which can exist for infinite number of years. Now, you might be puzzled. At one moment, I'm saying 10 years, and at other moment, I'm saying that infinite time. How? Because it can be renewed n number of times. But once renewed, it will get protection only for 10 years. You might think, what is the kind of renewation stuff? For renewing, you will have to pay the fees. As simple as that. If you want protection done by government, you have to pay the government. Okay. Another is the industrial designs. Industrial design is a cousin brother of patents only. Patents usually we get for inventions which involve mechanism as well as structure. Combination of structure and mechanism can give us patents, but only structure, only the aesthetics, only the ornamental shape or appearance of any produced good, if we want to protect, that comes under industrial design. It has nothing to do with mechanism. As an example, I gave you for a bottle. You take any kind of bottle, bottle for oil, containing oil, bottle for distilled water, jars of, jam and jelly. They are also a kind of bottle. So let that be anything. So we are not bothered about what is inside the bottle, how the tip is fixed, how they are sealed. We don't have anything to do with that. But what we are talking about, only the aesthetic look, the ornamental shape of a produced good is protected under industrial design. And this also, being an IP, it has got its own registration process. Once granted, we get protection of 10 years and extendable only up to 5 years. So maximum protection of 15 years can be granted for industrial designs. Then the last one, a very informal IP, That is a trade secret. So trade secret, for what we get the IP? We don't get an IP. So it is simply a very valuable information which should not be disclosed in public. That's what a trade secret is. And is there any registration? No, we simply have to keep it secret. And what is the time period? There is no time period. Till you keep it secret, generations after generations, it will be secret. And you can use it for creation of trade. So this is an overview of all major types of IPs. For what kind of imaginary work, or what kind of human brain efforts, what type of legal right we get, and for how long it lies. So this slide gives you information about it. Are you all with me?
Yes, ma'am.
Okay.
Yes.
Sir, I would like to ask how much more time I can get so that I can decide on what contents to be covered and what can be skipped.
You can take it, madam. Not an issue.
Okay, so I'm assuming that I'll get half an hour more, and I'll try
Yes.
to manage my contents that way.
Yeah, sure, ma'am. Yeah.
Okay. So I assume that all of you must have understood something like what can be an IP. If I get some such type of invention in mind, in what direction I should go, like what type of IP I should go. If I choose any specific type of IP, how much amount of period I can get as protection. So I hope these things are clear, and assuming this will move ahead and we'll see each of IP little more in detail. Let us talk first about patents, because patents is turning the economies of countries, and ultimately the economy of the world is being driven nowadays because of patents. It's like how much kilos of gold I own, that much rich I am. The same way the countries are considered as rich depending on the number of IPs, and in number of IPs, if we have more number of patents, that huge amount of revenue that country can have. So patents you can compare with gold. Okay, just for understanding, I'm saying it's not actually done, but for understanding. So it is valuable. The ultimate thing what I want to convey is it is as valuable as gold or diamonds or any other property we have. Okay. Patents are the exclusive rights granted for an invention. Exclusive means nobody else is allowed to use without the permission of the patentee or the patent holder. Okay. A product or a process that provides a new way of doing something. If it is a process, we can say a new way of doing something, or that offers a new technical solution to an existing problem. All this stuff can be treated or can be given for filing as a patent. What product or a process? So I may invent some such machine that might create something little bit faster than the existing machine. For example, a Xerox machine, let us take. If Xerox machine is taking, suppose 50 milliseconds to scan a document. And for example, if I develop a mechanism where the process gets completed in 1 millisecond. So what I'm doing, the machine is same, purpose is same, application is also same. Simply I'm making it more faster without deviating, without diluting its purpose or application or even the quality. Suppose I'm able to reduce the timing of scanning inside Xerox machine from 50 milliseconds to 1 millisecond, then I can file a patent on it. Okay. Now, for doing so, I might have developed some hardware, so that hardware becomes eligible to be filed as a patent. If for the same stuff, instead of hardware, if I might have developed a series of steps as a process, which is reducing the time of scanning, then that also can be protected as a patent. So in short, a product or a process which is giving me a solution to an existing problem. See, 50 milliseconds is not really a problem, but from 50, if I come to 1 millisecond, obviously we'll be more than happy, because the number of Xerox copies which one can drive in 1 minute would obviously increase. So if we are offering a new novel solution through a product or a process to an existing problem, then it becomes eligible to be called as a patent. The patents can be of electronic system. It can be a mechanical machine, like the floor machine, atta chakki. So that can also be patented. There can be a software product. Now here I would like to tell you something, that in India, the source code or algorithms, pure algorithms or pure softwares are not patented. According to Indian Patents Act, the softwares are not patented in India, but they are patented in any other countries. This is what a legal statement. But however, we have another way of doing it. If the software I'm bringing as a package, as a product, for example, MATLAB. MATLAB is a software, we all know. MATLAB is a software that cannot be patented. I mean, when they might have started developing, so it was not allowed in India to patent it. But the moment it becomes a software product, the moment it becomes hardware specific, we can file a patent even in India. And always in other countries, it is allowed. So a software can also be patented. Then medicines. You might also know that India is number one, still number one in medicine patents in the world. The number of patents and the list which I have shown in the earlier slides of my presentation, that showed the overall count of patents, including the technology as well as medicine and everything. But particularly if we consider medicines or drug industry, India still stands first in the world related to the patents associated with medicines. So a patent can be owned based on any electronic system. Now, when I'm saying electronic or mechanical system, we don't have any pure electronic system. Obviously, when we are using some products, there will be electromechanical systems also. There will be combination of different technologies. So all are patented. All can be patented. So when we say about patents, a patent can be given for any hardware system, any software product, any medicine, and also the designs. Now, what is different in the design? Industrial design. Yes, you can read it carefully. Yes, Pradeep has raised hand. Do you have any difficulty? You can ask, unmute yourself and ask. Pradeep Suryavamshi.
Pradeep Suryavamshi, do you have any question? If it is not, then lower your hand.
It seems there is no any question. So let us move ahead.
Continue.
Design patent, or in technical terms, we call it as an industrial design. It is a legal protection given for unique visual qualities of a manufactured item. It is very, very important that a manufactured item, usually a patent, a normal patent, when we talk about, it is a combination of mechanism and structure. So there is also structure involved, but that structure cannot be handled without any mechanism. If it is so, then we should go for a normal patent. But if I want to protect only the aesthetic look of a manufactured good, a manufactured item, then we should go for a design patent. Usually it is traditionally we call it as a design patent, but its technical name is industrial design. So when we talk about IPs, we talk or we say it like industrial design. But industrial design is nothing but a design patent which does not involve any mechanism, any process. It is limited only to the aesthetics of it. Then what term is related to patents? That is process patent. So in first point itself, I told it can be either a product or a process. But usually when we see a number of patents, and if we try to find how many are process patents, so majority of the process patents are related to drugs or medicines. So other than medicines, these processes does not matter much. I'm not saying they don't matter at all, but most of 99% of the process patents are of the medicines, because it matters. A small variation in the process, say temperature or filtering or sequence of steps, if it is altered, it has a very huge impact on the final product when it comes to medicines. So such process patents are granted mostly related to drugs. So these are few of the examples. This bottle, anybody tell me what kind of patent should be filed on it? Anyone quickly respond. This left hand side bottle, its side view and top view. Yes?
Design patent, madam.
Yes. It is design. And you might have also recalled what brand this belongs to. It is very familiar shape, right?
Coca-Cola.
Coca-Cola.
Right. So this design is so prominent that even there is no label attached to it, still we can identify just because of the shape. And this is the impact of intellectual property. And hence designs are also considered as an intellectual property, and they are treated differently than normal patents. Okay. Now, medicines, as you know, process patents can be acquired for medicines. Then this shoe, again a side view and the top view is shown here. A normal sandal, a chappal, can also be protected under design. Now you might have seen Woodlands shoes. They have got very particular shape and texture, and from its looks and color itself you can identify, though there is no label, that this shoe belongs to Woodlands. It is the same peculiarity of every brand. Now if you say cars, car, it is open top and this is a normal car. So whatever is the car, please mute yourself. Somebody has thank you. So when we talk about cars, it is a combination of thousands of patents. Few may be related to its design. You take design of the shape, the exterior shape of complete car. You can take shapes of even the windshields, the mirrors, side mirrors, lamps. You take anything. Even the wheel structures, the appearance of wheels. So all have got different shapes. So they are having industrial designs. Then inside the car, you take dashboard. There will be a music system. There will be hundreds of control systems, electronic systems involved, sensors, their actuators, and hell lot of mechanisms are involved. So all those mechanisms will be awarded with some patents. So and even the logo, the brand, logo will be a trademark. So I'm saying a car can be considered as a package of thousands of IPs. So it is not simply the shape which we look from external side, but basically it is combination of many IPs. So a product or a process, so that can be patented. Now there is a criteria. If any invention qualifies this criteria, then only the patent can be granted for it. What is that criteria? So it is novelty, inventive step, and industrial applicability. So the patents are given only for technological inventions. Now, what do we mean by this technological invention? See, ladies nowadays everybody goes in kitchen and they prepare different recipes. Simple, wangyachi bhaji. If you eat from your granny, it would taste different. If you eat prepared by your mother, it would taste different. And you might have developed a particular taste of any particular curry or any recipe. You like some recipes, you don't like some recipes, but there are day in, day out inventions going on in the kitchen. A very regular example I'm giving, isn't it? So that does not involve any patent. What involves patent is technological inventions. Okay. For this, I gave the examples of kitchen. In kitchen, every day there are inventions happening. Even if we change the process, the product will change in kitchen. But they cannot be patented. What can be patented? Only the technological inventions. And that too after qualifying the 3 criteria. What are the criteria? Novelty. Novelty means it should be completely new, which was not existing earlier. That is called novel. Then inventive step. It should involve inventive step. Means what? It should not be a routine for somebody expert in that domain. For example, I am an electronics engineer, but if I prepare a machine, mechanical machine, for me it would look very different and inventive, because I was not studied the whole 4 years of mechanical. So I might see that as an invention, that machine. But for a mechanical engineer, it would be a routine task. Or even for a mechanic, it would be a routine task. So though I look at it as invention, they might not. If your invention is different from this case, means if your invention, though I am an electronics engineer, though I prepared a mechanical machine, but still that machine is equally new to mechanical engineers, then it qualifies inventive step. It means not only my machine is novel, but it also involves inventive step. Okay, it is not a routine process for the experts in that domain. And third criteria is it should be industrially applicable. Okay, industrially applicable means it can be manufactured, it can be sold as a product. Only then it is treated as patentable. Now, what does that mean? Suppose I prepared a beautiful machine. Okay, beautiful machine. It may have novelty, it may also have inventive step, but it is not really, a product which many people would buy. It cannot be manufactured in industry on a mass scale. So still my invention will lose its patentability. One invention that qualifies all three criteria only are granted. Okay, many times it happens that, particularly in industries and more precisely in forging industries, the products they produce every day may have some problems. They might have filed even patents on that. For example, a car. Let us take Tata Motors, some recent car. Let us take Indica. So you might have seen hundreds of types of cars which are being manufactured in Tata Motors. But why there are so many different types? Because the earlier version might have some drawbacks they have overcome by the newer version. Every time it happens. And the most latest version, what we have today in hand, has got all the latest facilities, state of the art facilities, isn't it? But after a few days, we'll come to know that now no petrol engines, no diesel engines will exist after a few years. So though my car at this moment is very beautiful, technically at very higher end, but after a few years, the same stuff will sit on batteries and it will not use the engine at all, isn't it? So that kind of improvement keeps on happening. So such inventive improvements in existing patents are also patentable. Okay. Now, as there are patentable stuff, there are few rules and laws which say that few things are not at all patentable. Though they are novel, though they are inventive, though they have industrial applicability, but they are not patented. It is according to the Patents Act 1970. So the inventions contrary to natural laws. For example, E is equal to mc square. So we have been listening this since our school days. E is equal to mc square. So the moment we utter this, we get an image of Einstein in our brains. Am I right? Okay. The theory which is contrary to this natural law is not patentable, because till this moment, sorry, till now, nobody could prove another theory which goes against this law. So though it is invention, though this invention is novel, though it has an inventive step and even industrially applicable also, but it will not get a patent. Okay, scientific theories and principles. Ohm's law will never get a patent, because the moment Ohm's law is protected under patent, nobody else will be able to use. And if we are saying nobody else will be able to use without permission or anything, then you just think of, if this would be patented, then what could be the cost of all the mechanisms which are happening in electrical domain? Nothing would go, isn't it? So such scientific theories and principles are for the betterment of technology. They are for the betterment of the society. So they cannot be protected, because it is an exclusive right. We cannot give right completely exclusivity, isn't it? We will give Nobel Prize. Yes. We'll give Nobel Prize, we'll give Padma Shri, Padma Vibhushan, but we don't give a patent. Because the moment we give a patent, that becomes his sole proprietary. And with the wish of that, patentee, only will be able to use his invention. Okay. Mere discovery of living or non-living things. Mere discovery means it was existing since ancient times, but now I got to know it. Now the world comes to know, means discovery of anything is not considered as patentable. Then new form or admixture or the property or use of known substance. For example, salt. If I come to know that if I mix salt with milk, some byproduct comes. So today I may find that as inventive, but it is simply what? It is the admixture of two components. There might be some chemical reactions happening inside the milk molecules and the salt molecules. So that is not an invention. Yes, it is novel. It has got some inventive step, but somebody will buy it? No, nobody will buy it, because it is simply an admixture. So there are few things which are considered as non-patentable. One more thing which I did not include here is any invention related to atomic energy. Just imagine atom bomb. Atomic energy is useful. If I invent an atom bomb, is it novel? Yes, it is novel. It has got inventive step. Yes, nobody else has done it before, and the experts in that domain will feel, yes, it is an invention. Can I sell that as an industrial product? Yes, I can sell. Atom bomb I'm talking about. But suppose I produce 1,000 atom bombs here and sell it to Pakistan. What Pakistan will do, what China will do if they purchase it? They'll just throw all those bombs on us. So we don't give patents to such inventions also, though they qualify novelty, inventive step, or industrial applicability all over the world. Nobody gives permission to patent it, such inventions which are contrary to living beings. We don't give patent. Okay. So there is a separate patent law, and it has got a big history. But in reality, in India, we have started implementing it from 1970. There are many amendments. Now, looking from the perspective of your syllabus, particularly speaking of the mechanical students, the syllabus cannot be completed in a little time. So I'll just run through these details. There is a detailed patenting procedure. There are different offices. So there are some steps also for a patent, and once granted, you will receive such certificate. Till now, we spoke only about patents. Let us talk a little about copyrights. Anyway, I already introduced you what are copyrights. So the rights given to the creator of any literary or artistic work are called as copyrights. Literary work like novels, poems, books. Then artistic work like paintings, drawings, music, tunes, or the live performances of anybody, and also the computer programs. Now you might remember I told that a pure computer program or a source code does not get a patent in India. Then what kind of IP? Somehow I have to protect my program, right? If I have a source code of a big program, which may change the methodology of some software. Okay, so that source code cannot be patented, but that can be protected under copyright. So such programs, databases, or even movies are copyrighted. Okay, and once copyright is granted, such symbol, what you can see, C inside a circle. So that somebody can use. Now, there are even many details and updates nowadays using which a temporary copyright also can be taken. So you can search on Google how it can be done. But for copyrights, I can say they are given to any literary or artistic work. among all IPs, the copyright infringement means breaching the Copyright Act, means breaking the rules of copyright. The punishments and everything is severe in copyrights compared to all other IPs. So the cases may go to civil court, and there are even criminal remedies also for it. And there is an act, Copyright Act 1957, which governs all the laws related to copyright. Now let us talk about trademarks. Trademark is something which is the indicative of the brand. Okay, it is a distinctive sign that identifies certain goods or services produced or provided by an individual or by a company. So trademarks can be a simple combination of alphabets. It can be a combination of alphabets plus words, numbers. Then it can be a combination of designs. It can be a combination of different colors and shades and backgrounds. So if one has to go for filing a trademark, he has to formally submit exact visualization of the symbol. So including the font, color, then what do we say, shape, style, arrangement, everything. So there are registered marks as well as I'll show you. There are some service marks. There are registered marks as well. You can see Dr. Reddy's. Now these days people are suffering from flu and cold and cough. So you might have purchased many medicines, preferably by Dr. Reddy's lab. So you might have seen this particular symbol prominently. So it is a trademark. Okay, trademark means the person who is owning that business, whatever mark he decides to use, that becomes a trademark. But there is something called as a registered mark. Okay, now when we write like this, Dr. Reddy's, Dr. Reddy's, if it is written like this, and if it is not registered to the government, then anybody else, suppose today I prepare some kind of kadha, and I'll sell it with the name of Dr. Reddy's. Dr. Reddy's will not be able to, file a case against me because they have not registered that name as a trademark. But I will take its benefit because just because they have not filed a trademark, then I can use their name. So this is an imaginary case or example I'm telling you. Then what is a registered mark? Registered mark, you will see McDonald's at the bottom right corner. You will see R in a circle. That means it is a registered mark. So it has got a legal protection given by governments. Okay, this trademark is very much territorial, means this mark has to be filed in India separately, filed in US separately, filed in some other country separately. We have to separately file it. Similarly, IBM, at the bottom of IBM, you will find R written in a circle. Means it is a registered mark. But on the top of Google, you will find TM. So it is not registered. Suppose if I want to use this Google, particularly this shape, this color, this font, everything as it is on, say, cap. We wear caps, right, in summer. So on cap, I have to use this. I can use just because they are not registered. So they can't, prohibit me from using it. But wherever it is written like R, it is a registered mark and it is an indication like just because it is registered, nobody else is allowed to use it without their permission. So as we discussed earlier, trademarks can be given for goods as well as services. So there are 34 categories of goods to which trademarks can be awarded, and there are 11 services to which trademarks. Actually, while filing a trademark, we have to mention for which type of product or which type of services we want this trademark. So there we need this information. Now let us talk about geographical indications. So one example I already gave you, Nagpur orange. Similarly, there is Kashmiri shawl. Why I gave Nagpur orange? It is naturally grown. But Kashmiri shawl is not naturally grown. People literally weave it. Just the thing is, the people from Kashmir, with the use of a specific type of wool, which is drawn from the sheeps which are found in Kashmir region, and which has got a specific weaving style. The moment ladies will have a different taste, they understand it better, because there is a very fine weaving type. There is a very beautiful pattern of design which is woven on the Kashmiri shawls, by looking at which we immediately identify, yes, it is Kashmiri shawl and it is not of anything else. So though it is
Deepak sir, whether the voice is audible?
Yes, sir.
Madam, voice is audible?
Sir, I think it's she is not audible. Also can't hear her.
Just a wait.
Hello.
Yeah, madam. Now it is audible.
I think my connection was broken.
Yeah, now it is okay.
Okay, sir, is my screen visible?
No, ma'am.
No.
No.
Okay, I'll reshare it.
Yes.
Now, is it visible?
Yes, ma'am. You can do the full screen. Yeah.
Sir, could you listen to geographical indications earlier?
You can repeat, ma'am. Yeah, once again.
Okay. Sorry.
It's okay, ma'am.
We were talking about geographical indication, which is considered as almost the last IP for at least today's lecture. Though the stuff is naturally available or a man-made thing, but if it is associated with some geographical location, a group of people can go and file a geographical indication as an intellectual property. Now, you might ask me, when we say intellectual property, it is creation of brain, then a tea or Kashmiri shawl, how come that can be a creation of brain, or even the Nagpur orange? So it is something like this. It is not directly the creation of brain, but the people who are living there, though in Darjeeling or Nagpur or Kashmir, they have got a particular skill set using which they can produce the best quality of either Nagpur oranges in Nagpur side, or the best quality Darjeeling leaves in Darjeeling region, or the best quality shawls in Kashmir region. So this ability, this particular feature which is available in a specific geographical location has got some impact, and hence, and this is also not a proprietary of one individual. There are hundreds of farmers who would be farming in Darjeeling for the tea. There will be thousands of workers who would be plucking the tea leaves, who have sense of plucking the right leaves, isn't it? So the whole process is involved. The tea bags or the tea powder which comes at our home is only a final product, but we don't know how many people and how many processes are involved till its preparation. So a group of people is given this right. Okay. Now there are some success stories which I wanted to share, but I'll share only one because the time is running like anything. Success stories, like this is a very, very famous story of a school girl. Now she must be even graduated, because in 2011 the patent was filed, and then this girl Ankita was in 9th or 10th standard. Okay, and when she was in 9th standard she filed it, and when she was in 10th standard it was granted, awarded. So what was the patent all about? See, she is a girl from a lower middle class family. Her father used to be in a Xerox machine center, and he used to staple the Xeroxed pages. Now you can see here, she used to help in the leisure time to her father while stapling. Her father used to Xerox the papers and she used to staple. But many times she faced a problem. Please listen carefully. She faced a problem of, all of a sudden, the stapler pins used to finish, and she would not realize till they are finished. She wanted to understand. The problem was, she wanted to understand that now very less number of pins are remaining in the cartridge of that stapler. Now this was the problem statement which she took as a challenge, and a very simple solution given to it is, the last 10 pins are colored with red. So the moment she is keeping on stapling and stapling, and the moment she sees that on paper now red pin started, it means she understands. When she looks at the first red pin, she understands that only 10 pins are remaining and she needs to replace the cartridge now. So a very simple problem, and more simpler solution she provided, but the whole stuff was filed as a patent and she owns that patent. Now, what experiment she did, what she used to do is, she used to paint the last few stapler pins with red nail polish. See, just look at the amount of intelligence and complexity. It is very simple. It is no way complex. So why I'm sharing this story is, patents are not a very big deal always. They are, of course, but not always. Simply you have to pick a particular problem and you have to solve it technically. Okay, so this invention has given her a way to explore in her, to make her life more easy. So this one story I purposely wanted to tell you, that you don't keep yourself hidden, or prohibit yourself for exploring. So we have almost come to an end of today's session. We have seen starting from why one should know about the IPs. Then we saw what exactly is an IP. Then we saw its types. Then in each type, what kind of invention or what kind of creation of mind gets involved. Then we saw patents in more detail because it is much relevant to engineering students. So I took it little more in detail. And then we also saw some examples of industrial design, then copyright and trademarks also, including geographical indications. And now we are at the end. Yes, all theoretical stuff is over. Now, the takeaways for researchers and faculty, if at all any faculty are listening to this lecture, they should keep in a mind that if you are doing PG, if you are doing PhDs, then keep focus on what inventive component you are involving in your research, though it is PG or PhD. There is always some kind of inventive component. If you are a genuine researcher, if you are buying projects from outside, particularly for students, you will not find any patent or you will not even get any revenue out of it. But if you are really keen, if you are a good engineer, you will definitely find some inventive component in your research. Okay. If not, if you don't find anything inventive, at least you can have a copyright of your thesis. Because if you write it by your own, you won't get caught in plagiarism, and you can just publish your report, project report, as a book and own its copyrights, earn out of it. Because you have seen the term for copyright is your lifetime, and even after your lifetime, 60 years. So though it is 100 rupees per month, why don't you want to get it? Isn't it? Anyone should go for it. Then, for students, what is the takeaway from this session? Usually, I give lectures to engineering, pharmacy, and even some science colleges also. So, if you are any science student, I'm particularly saying science. After that, engineering comes. Basically, you have to be a science student first. If you are a science student, you come across number of projects. Now, if you are a diploma holder, you might have done some project in your diploma. If you are in final year now in engineering also, there also you have to take a project. Please take project in some such way. Now you are in the second semester of final year, so I can't assure that all of you will follow this particular suggestion, but just keep in mind, and you can share this with your juniors as well, that when you are choosing a project, please don't choose a project, please choose a problem statement and solve it by your own. I have given you a story. I told you a story wherein a very simple problem was solved with a very simple, a comparatively more simple solution. But that lady, that girl is owning a patent. She can sell that patent to anybody, and just by sitting, she can earn anything. Isn't it? So, if you have a project, very beginning, you can think of it. Second, if you are science students, then you can think of generating an IP and have a plan of selling it, have a plan of production. If you have that capacity and family background, please think of it from your very early days of graduation. Third, you can become a patent agent. So you might feel a bit weird when you are listening to it, but you can become a patent agent. You might think, why I have to be a patent agent? See, it is a government stuff. I mean, like lawyers do practice with their license, doctors do practice with their license. There are hardly any engineers who practice with their license. Have you heard it ever? No. But yes, patent agents also practice like lawyers with their licenses. And how do we get that license? We simply have to appear for an exam, which happens almost every alternate year. You have to qualify that exam, become a patent agent, and help others, help the society to create their patents or their IPs. Okay, so this is one, what we say, domain where you can think of your career to build. If any one of you has got industries at your family industry, or if you wish to have your startup, for startup it is very essential that you must have a patent and invention in your hand. If you have an invention, you can straight away go and register your firm as a startup, and you will get hell lot of benefits from government, because the Startup India campaign and Stand Up India campaign is happening like anything. There are hundreds of schemes which you can benefit from. Okay, so these are a few things for students and faculty. As a college, what benefits we have by having an IP? I'm saying IP, not only patents, because now, as fortunately the subject is there for mechanical students, I would like to tell that instead of going for a patent, you try to file designs, industrial designs. Okay. If there are any faculty who are listening to this, mechanical faculty particularly, who are listening to this session, can help your students filing an industrial design, because it is comparatively easy. The process is comparatively easy, the fees is comparatively less, and it gets granted quickly comparative to any other patent. Okay, either product or process patent, the design patents are granted quickly, and that will definitely boost it will help you in increasing the NRF ranking or area ranking, or even for NBA and NAC. Everybody will ask about your IPs. So though not patents, but at least you first start with some designs, and ultimately we have everything for contribution in the society.
Ma'am, your voice is not audible right now.
Am I still audible?
And now it's okay.
So I was telling you what you can take from this session, all the takeaways for faculty, for students, and ultimately for the institutes and overall to the society. So keep an eye on open-ended problem statements, though you are a faculty or a student, though you are in third year or final year, though you are from mechanical or any other branch, does not matter. Keep your eye on any open-ended problem. Try to solve it by your own. Take that solution methodically, prepare documents, and go for filing some or other IP. Now, in case of engineering students purely focused in the engineering studies, will get easily design patents and normal patents. If you want to have your startup, or if you have an industry, family business or so, you can also think for having trademarks. Or even if your family background is from farmer's side, and if your locality is growing some particular crop, or if you have some particular feature, like in Kolhapur region, there is also a geographical indication filed for Kolhapuri chappals. It is very common. You might laugh even at this when I'm saying this, but this is an intellectual property which a particular community owns, and nobody else is allowed to use that Kolhapuri chappal label, even label. It is not allowed for anybody else from other regions to use this label. If at all I have to use, I have to particularly go and purchase the chappals from that particular community from Kolhapur only. So they have got such kind of monopoly. So even you can think of geographical indications. So this is overall, a review, kind of review for all the IPs, and you can think how many IPs are surrounded with. Just you have to be quite vigilant enough. So these are some reference sites. ipindia.nic.in is the premier site where you find Indian patents. You can also see the process of filing a patent or a copyright or even a trademark on the same website. Even WIPO portal, then patent scope is there for search of patent. So these are few sites which I also have referred while preparing. And that's all. Thank you, everyone. You can see there are different logos. I purposely put around thank you because you should know them. This is what technology is surrounded with. Sir, my contents are done. So if we have some questions, I'm open for it.
Definitely, madam.
Hi, ma'am.
Yes.
Yeah, Pratik this side. So yeah, thank you so much for your whole guidance. So before this lecture, we was only curious that we only know that there is a one method to register your idea. That's the patent. But after this lecture, we got an idea. There are too many different types like a copyright and trademark and the patent as well. So yeah, this is definitely a very helpful for us as this is our early stage of the career. And yeah, ma'am, this is very helpful for us.
Yes. Thank you.
Yeah. And guys, if anybody wanted to give the feedback or if you guys having any questions for a ma'am, so you can quickly raise your hands so that we can give you the access to unmute yourself.
Even if any faculty wanted to share anything, so unmute yourself.
Good afternoon, ma'am.
Good afternoon,
Myself,
sir.
myself Jagdish Mudegaonkar. Suppose if I am having any idea in my mind and I have to check whether the patent is filed on that idea previously. So if there is any source available online for that.
I did not get your question, sir. Please, can you please elaborate a little bit?
Yeah. Suppose I having one idea and I have to file the patent for that idea, but I didn't know whether that patent is filed previously by someone or not.
Okay.
So if there is any source for identifying or for searching whether that idea is patented or not.
Okay. Sir, there is very simple way of doing it. Initially, you can search it on Google Patents, not normal Google, but there is like Google Scholar, we also have Google Patents. So one can go and just type your concept or even keywords, more particularly. The way we search for any paper, isn't it? When we write a paper, we also search for some reference papers and look what other people in the same domain are working on. The same way we can do it for patents. So Google Patents is a very basic and preliminary level search engine. But if you want to go in depth, then there are a few more websites like InPat is there for Indian patents for searching. Then eSpaceNet is there. Even you can Google like what are the sites to be searched for searching for a patent on some concept. You will find at least 5-6 different databases. Actually, they are different databases. Like we have US database different. Then we have Chinese database different, Japanese different. Okay, so these all databases will carry their own information. So we can search any concept with the help of complete statement, like your problem statement, or select your keywords and put it on these websites. To start with, you can use Google Patents.
Thank you, madam. Thank you very much.
Welcome, sir.
So yeah, guys,
Anyone want-
if you guys having any other, yeah, please raise your hands.
Okay, there is a one instructions to all the participants. Please fill the feedback as well as all the details in given that link for the certificates also. So it is given in a chat box. If anybody having that any question, any query from student side and the faculty side, please unmute yourself and ask.
Madam,
Yes, sir.
I would like to ask one question.
Please, sir.
Who can file a patent for geographical indicators?
Actually, there are some kind of associations or basically group of people. Like in Kolhapur, the people who it is not an individual particularly. Any individual cannot go and file any geographical indication. An organization has to take lead, and through some patent agent, you can do it.
Okay. So means it should not, it can be a group of people. It should not be an
a
organization.
group. It should be a group of people. Maybe through an organization, they can do it. Like some associations and all people have. Farmers associations, or in case of that Kolhapuri Chappal, they have that Chappal manufacturing
Their own
association.
association, yeah.
So those also can approach.
Okay. But it was very nice. Students
you,
might
sir.
have understood and they are now aware of what is patent and how it can be useful for engineers particularly. So I think, and finally, students might have got idea of that subject.
Yes, sir.
Overall, they can go with the curriculum
Yes.
of DIVA 2. So I think it is very nice.
Thank you, sir.
Yeah, there is one question from my side, madam.
Please, sir.
For design patent, how much
Hmm.
fees applicable or required?
Sir, if you go individually, it would be in few thousands, less than 10,000. I mean, it would be like 1,600 or so. So even less than 5,000 would be the fees if you file it individually, like by your own. The IP India website, which I have shown at the end of my session. So that that itself gives you all the guidelines. I mean, everything in detail is given in that portal. You just explore it. There will be a section for industrial design. You go into it. There will be a procedure. You can search earlier filed designs also there. And there will be different PDF files showing you what are different forms you need to fill while filing the design. Now, I'm saying this when you go individually. If you want to do it through any agent also, you can just go there. You need 7 what do we call views. Like we have the top view, side view, and tilted view, 3D images. So all such 7 diagrams you need. If you have any machine or gadget or anything for which you want to file a design, you need their 7 views. With that, you will have to give some information also, written information. And that is how you can go ahead, sir.
Okay, madam. Yeah. Thank you, madam. Anyone
Welcome,
wants to? Anyone want any faculty, any students? Raise your hand. If it is not, then we will go towards the last session of last part of this session is a vote of thanks. Please, Pratik.
Okay,
Pratik.
thanks, sir. Yeah. So now I will request to the VL Jagtap sir to give the vote of thanks. So over to you, sir.
Hello, am I audible?
Yes, sir.
Yes.
Okay, first of all, good evening to all. Here, myself, Professor VL Jagtap sir, for the vote of thanks. It gives me a great pleasure to give a vote of thanks here. Now, I am thankful on behalf of our college to our Honorable Trustee, Rohan Paricharak Malak, for giving us permission to arrange this webinar. I am thankful to our Honorable Principal, Dr. S.P. Patel sir, for guiding and encouraging us to conduct this webinar. I am very much thankful our chief guest, today's eminent personality, Professor Mrs. Bidwai Madam. In spite of his busy schedule, he gave us time to deliver his very nice speech on intellectual property rights. Madam has very nicely explained the importance of intellectual property. Actually, what is intellectual property rights? Different types of intellectual property, patent, copyrights, trademarks, etc. The applicability of these patents. So very nicely, Madam has explained a detail about the intellectual properties. This session is useful to all faculty as well as students. Definitely, all the participants have taken the benefit of this, Madam. Now, I am thankful to our Vice Principal, Dr. J.L. Mudegaonkar sir, Dean Dr. Abed Patel sir, R&D Dean Abed Patel sir, Dean Academic Joshi sir, Mechanical HOD Panchal sir, all other department HODs, all faculty members, and not last but not least, all the student participants who have participated in this session. And at the last, I want to conclude the vote of thanks with one of the Martin Luther's great saying: an individual has not started living until he rises above the confines of his individualistic concerns to the broader concerns of all humanity. Thank you. Thank you all. Over to you, sir. Pancha sir.
Yes, sir. There is one request to all the participants and the faculty. Please, on your video, so we can take that the screenshot. Start your video, so we can take that the screenshot, and then we will conclude our this session. So I request to all the faculties, dignities, and the participant.
Sir, my camera has an issue, so I may not be able to.
Not an issue, madam. Not an issue. Yeah. It's for the only documentation purpose.